I don't want to get too much into this and dwell too much on this point because it doesn't get to the heart of legal argument, but it does add some color to what's going on, right? This isn't a good faith effort from an attorney general to prevent donor fraud. Platkin, the AG, has a history of attacking pregnancy resource centers in New Jersey. A few years ago, he issued a consumer alert that he drafted with Planned Parenthood just to make sure everybody in New Jersey knows they don't do abortions. He has a very prolific pro-abortion history. I think provided like $5 million of funding for the expansion of abortion in the state. So it's not like this is out of the blue. First Choice did something clearly wrong and had a bunch of complaints. No, it's coming kind of out of nowhere and after a history of a hostile AG against these sorts of centers.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week we'll be having an episode with the theme of this Supreme Court case is important, but it's not about what the headlines are telling you it's about. We're going to be discussing two cases for which the U.S. Supreme Court heard oral argument last week. One is First Choice v. Platkin, involving a pro-life pregnancy center in New Jersey, and the other is Olivier versus City of Brandon, which is a free speech case. Now, like I said, both of these are going to be headline generating. They already have been, but the actual legal issue that the Supreme Court was deciding in both cases was not the central issue that you're hearing about in the headlines. So for that reason, we wanted to dedicate this week's episode to these two cases, focusing on the general facts, what the legal situation actually is that's being addressed by the court. And then I think Joseph in particular is going to hone in on some of the issues that were at play in the oral arguments last week. So lots to cover on both. We're going to try to keep the time tight, but let's see what we can do. Let's start with First Choice. So again, last week, the Supreme Court heard oral arguments in this case, First Choice v. Platkin. This dispute began in 2023 when New Jersey's Attorney General, Matthew Platkin, issued a subpoena to the Pregnancy Resource Center, demanding that it provide him with his office with a lot of things, including donors identifying personal information, as well as a lot of the information they're giving to their clients and so on, ostensibly because there were concerns with potentially misleading information that was being given to the women coming to this resource center. At least that's what the Attorney General's office was saying. And the subpoena was a civil, non-self-executing subpoena, which is relevant. We'll get to that in a few minutes. So when First Choice was hit with this subpoena, there were concerns, among other things, with donor privacy and with the chilling of constitutional rights. And so First Choice filed a 1983 lawsuit, which is a federal claim that you're probably familiar with. If you're listening to this, we've covered a lot of 1983 related cases before. So the 1983 lawsuit claimed that the subpoena violated First Choice's constitutional rights. Shortly after that, Platkin, the Attorney General, asked the state court to force First Choice to comply with the subpoena. There were a couple of attempts to get First Choice to comply with the subpoena. I don't think any of them were successful, which also comes into play in the facts of this case. And in the process, First Choice's federal lawsuit was dismissed for lack of ripeness. And the decision was based on the idea that the subpoena doesn't itself carry the force of law, but rather would require an order from a state court to actually compel compliance. So because there was no compulsion by the government, allegedly there was no injury or no action that would actually trigger a right to file a 1983 constitutional claim. So just to put this in context on our theme for the day, this is being framed as a battle over a pro-life pregnancy center's rights being infringed by a hostile state attorney general. And in a sense, those are relevant facts. That is true. That is the gist of how this controversy started. But that's not the legal issue at play in front of the U.S. Supreme Court. So the legal issue that the court is addressing in the oral arguments that were heard last week and in the decision that will come down in 2026, I'm going to just read the question as presented by First Choice's cert petition, because that is, I believe, the question that the court accepted verbatim. And it says this. The question is, where the subject of a state investigatory demand has established a reasonably objective chill of its First Amendment rights, is a federal court in a first filed action deprived of jurisdiction because those rights must be adjudicated in state court. I know that's a mouthful, but basically what we're saying here is we have a who filed what first and what has to happen next kind of situation, right? So you get a state subpoena the first choice responds by filing a federal action, and then the state attorney general says, well, hold on, there's a state subpoena, there's a state court procedure going on to determine whether you have to comply with that subpoena. It's not ripe for a federal lawsuit. So that's what we're dealing with here. When there's a state action, can the pregnancy center in this case file a federal action, or do they have to go through the state court process first, or rather instead, as the case may be? We'll get into that as well. So a couple things that I want to get into here. First, the central issue that was debated during the oral argument is whether or not First Choice's constitutional rights have actually been violated already, right? Under New Jersey law, as I said, the subpoena, it's non-self-executing, it's a civil subpoena. So basically, a state court has to order First Choice to comply before First Choice would face any penalties. So the argument here is, well, we gave you this subpoena, but it's a civil subpoena. If you ignore it, nobody's violating your rights. Nothing will happen to you unless and until a court says comply, at which point maybe you have a constitutional claim. That's the argument of New Jersey in a nutshell. But as observed by several justices during oral argument, I think Joseph will get into this a little bit, First Choice's constitutional rights likely already were violated upon the issuance of the subpoena, because the subpoena itself does chill the speech of the donors to First Choice and impinges rights to free association, right? If donors are seeing, oh, wow, if we give to First Choice is under subpoena, the Attorney General of New Jersey has issued a subpoena asking for all this donor information, contact information, and so on. Maybe we're going to think twice before we donate to this organization, because they seem to be in the spotlight, and maybe donors don't want to be themselves in the spotlight of the New Jersey Attorney General. It's a reasonable argument that alone, the act of issuing the subpoena, chills the free speech and associational rights of the donors here. Completely unrelated to Napa Legal, so taking off my Napa Legal hat, this is not endorsed by the organization, but I actually did just write an article on donor privacy and why it's an important fight to be having among conservative organizations in an unrelated case called Buckeye versus IRS. So by the time you're listening to this, last week that was published. But I think it's a really important issue. Like, donor privacy is a hot button issue to the extent that donors are not anonymous or able to be anonymous, when they're worried that their information is being databased in places more or less secure, like state or federal government agencies, that can actually deter them from donating, and that's a constitutional problem. So another issue that I'll get to in a moment is that a ruling against First Choice here, I think, and some at the oral arguments think, would render many appeals unreviewable ultimately in federal court, right? If certain constitutional claims, like the ones here, have to first proceed through state court and go through this process of motion to compel and the subpoena, and you have to follow the state court route, these decisions might end up being subject to the doctrine of what's called res judicata, which means the thing has already been judged, and then you can't therefore bring the same case again. So there is a concern, and there's precedent to back this up. We'll get to that in a couple of minutes, but that if you have to go through the state court first, if the New Jersey Attorney General is right here, then it might actually preclude a lot of cases from ever going to federal court and having the right to challenge under 1983 in federal court. So it's quite a complicated case. The cert petition, if you look at it, including all the exhibits and the transcripts, over 250 pages long. I don't want to dive too deeply into the weeds. It could take us all day, but I do want to touch briefly on a couple aspects of the case itself. And then I'll turn it over to Joseph, because I know he followed the oral argument quite closely, and we'll probably have some supplemental things to say. So first point, the general argument from New Jersey, right, that the subpoena was a non-self-executing civil subpoena, the argument makes sense. It's at least possible, if not convincing to me, right? The argument goes, look, there's no penalty for noncompliance, right, until a state court mandates production of the documents. So the subpoena sitting there, it's a civil subpoena. It's not actually infringing on any rights. It's not making you do anything. I have questions about that line of argument. But the further the argument goes, right, apparently the state court had refused on more than one occasion to issue such orders. The New Jersey Attorney General did go to court and did try to get First Choice to comply, reading from the record here, and was denied. So there was never a motion to compel issued by the state court in New Jersey. So New Jersey's argument goes that, listen, the case is not ripe because the existence of the subpoena alone doesn't sufficiently chill any constitutional rights. Nobody was making First Choice do anything. So the question then, which the court spent a lot of time on, is without a court's motion to compel, is the existence of this civil non-self-executing subpoena enough to allow first choice into federal court under Section 1983? It's a big question. And it's an interesting one with dueling precedent at play, admittedly. But I'll just say, without getting into the legal arguments, if people are really interested in this, read the filings, listen to the oral arguments, but we just want to make it clear what's going on here, right? What the actual issue is. I just want to say, on a gut level, I do find this argument to be a little bit troubling for the reasons I said before, that just the existence of the subpoena, it's a public record. It's going to potentially chill the association rights of donors. I think that's pretty clear. But also, it's not a frivolous document request from a random citizen, right? This isn't like a FOIA request from some disgruntled citizen that says, give me all your documents, and it's clearly unlawful, right? This is a subpoena from a state attorney general demanding quite burdensome requests, right? It's you can't just say, well, this is harmless, right? It's not self-executing. Nobody's making you do anything. I know this is a gut reaction, but come on. The state attorney general has issued a subpoena. This is not nothing going on, nothing compelling. This is a big deal. So in my mind, saying, listen, there's no real threat, no court has required you to comply with this, feels a little bit to me like there's no real threat. We might be pointing a gun at you, but there's no finger on the trigger, never has been. Plus, maybe there's not even a bullet in there. It's like, this thing is harmless, but it's not harmless. If it gets executed, it becomes quite harmful. And then I think New Jersey basically admits in their response to the cert petition that, yeah, if there was a motion to compel, then we're probably at a point where there's a constitutional question, but the time is not here yet. And in my mind, that's a little bit of a game because the thing is powerful, right? It's a subpoena from a state attorney general. I don't want to belabor this point, but I think it's a little bit, if not disingenuous, then a huge stretch to say that, no harm done. We haven't compelled you to do anything. The state attorney general issued a subpoena and started an investigation. That's not nothing. And I will quit on that issue because I could probably go on and repeat myself. But before I turn it over to Joseph, I do just want to mention one more issue or revisit one more issue, and that's the gravity of the res judicata question. Right, most of our listeners are legally savvy and already understand what res judicata if you're reading ecclesiastical Latin, but I so assume res judicata is how most people will say it. So this is the legal doctrine that a case can't be tried because it has already been finally decided by a court, right? So the easy example is if you have a medical malpractice claim, right, and because you have maybe parties in different states, you choose to file that medical malpractice case in federal court rather than state court, right? You lose the medical malpractice case in the federal court, and then you try to file the suit again in state court. Your action in state court is going to be dismissed on the basis of res judicata. The thing has already been decided, and you can't roll the dice again in a different court, right? That's a common, age-old doctrine in American law, and this is a real fear that First Choice expresses in its cert petition, and I think they have precedent to back it up. So they say, if New Jersey wins this argument, then it forces victims of potentially unconstitutional civil subpoenas to argue the issue through the state court process. But if they are forced to first go through the state court process because it's not yet ripe for 1983, and then they lose the argument in state court and there's a final decision on that, then there's precedent. The Supreme Court cites a precedential case called Nick with a K, K-N-I-C-K in particular, saying that res judicata may then bar parties like First Choice from filing a federal 1983 action. That's a huge problem. If the current facts are not ripe for a 1983 action now, but post-state court, it might be too late for a 1983 action, there's a real concern that there's really no window for a case like what First Choice has here to ever get into federal court on a 1983 claim. So I think victims of subpoenas that threaten constitutional liberties like this may effectively lose much of their ability to file 1983 actions if Platkin, the Attorney General in New Jersey, is victorious here. So that's not an unreasonable fear, right? 1983 actions are very much meant to be a federal remedy for people who have their constitutional rights violated to go to federal court and have redress for those injuries. So this could potentially be a workaround to keep a pretty large swath of potentially unconstitutional actions from ever making it into federal court under 1983. So I think that's a legitimate argument. I think it's very troubling. Joseph, I'm going to turn it over to you, and I'd be curious to hear what you have to say, either about anything I've covered or just what you heard at oral argument the other day.
Yeah, so to start, like you mentioned, the issue of whether or not the subpoena is self-executing or non-self-executing plays a big part, because if it's not self-executing, then the state is arguing there's no constitutional injury yet to warrant first choice getting into federal court under a Section 1983 claim. The thing is, though, the subpoena does not look non-self-executing. It's written in a very authoritative manner, so much so that a reasonable person could think that this carries the weight of law, and if I don't comply, I'm actually breaking the law. I'll read directly from the subpoena briefly. It opens by saying, "You are hereby commanded to produce to the New Jersey Division of Consumer Affairs the following," and it lists all the documents. It's addressed by the Attorney General and the Deputy Attorney General, and by, quote, the state of New Jersey. It says twice, actually, failure to comply with this subpoena may render you liable for contempt of court and such other penalties as provided by law, which this can include dissolution of a nonprofit, which is just a death sentence. It says you are reminded of your obligations under law to preserve documents and information relevant or potentially relevant to this subpoena. That doesn't sound terribly non-self-executing to me. This sounds like the state of New Jersey is knocking on my door and demanding me to hand something over. And if I don't, I'm breaking the law. And the justices keyed on this point a couple times during oral arguments. Justice Kagan actually stated that an ordinary person, one of the funders for this organization or for any similar organization, presented with this subpoena and then told, but don't worry, it has to be stamped by a court, is not going to take that as very reassuring. So technically under New Jersey law, sure, it's not self-executing, but it's sufficiently authoritative for a reasonable individual to think that they're breaking the law. And in that way, objectively constitutes a constitutional violation by chilling First Amendment protected speech. So that's why the non-self-executing question is so important, because if it doesn't actually cause any constitutional injury, then it's not ripe under Section 1983. But if it's reasonably authoritative, if a reasonable person would believe that they are breaking the law and there is a chill of speech, then, as it seems like the justices may seem to be leaning towards, there is sufficient injury to open the door for a 1983 claim. First Choice's attorney pointed out the subpoena doesn't say comply if you want to, but rather you could get dissolved if you don't comply. And second, just to close on First Choice here, I want to bring up an important series of questions that Justice Thomas asked the Attorney General's lawyer. And he asked a couple times if the AG's office had any complaints against First Choice. And a couple times, the attorney had to admit that they had no particular complaints against this particular pregnancy resource center. Basically said that the reason they opened this investigation and issued this subpoena is because First Choice's website isn't super clear. And Justice Thomas noted that issuing a subpoena and beginning an investigation is a very burdensome way to find out if somebody has a confusing website. I don't want to get too much into this and dwell too much on this point because it doesn't get to the heart of legal argument, but it does add some color to what's going on, right? This isn't a good faith effort from an attorney general to prevent donor fraud. Platkin, the AG, has a history of attacking pregnancy resource centers in New Jersey. A few years ago, he issued a consumer alert that he drafted with Planned Parenthood just to make sure everybody in New Jersey knows they don't do abortions. He has a very prolific pro-abortion history. I think provided like $5 million of funding for the expansion of abortion in the state. So it's not like this is out of the blue. First Choice did something clearly wrong and had a bunch of complaints. No, it's coming kind of out of nowhere and after a history of a hostile AG against these sorts of centers. Great. So with that, we'll be moving into Olivier, the city of Brandon, Mississippi. We're going to go with Olivier for his pronunciation, where the Supreme Court will decide whether or not a street preacher can challenge the constitutionality of a speech restriction in federal court.
Yeah, now this is again on our theme. You're going to see headlines about the underlying First Amendment, free exercise, free speech kind of issues. They're not the issues that the Supreme Court is hearing. But they are important. So before Joseph gets into the oral argument, as well as the complex legal question that's actually at issue in this case at the Supreme Court, I do just want to spend a moment on the underlying First Amendment violation, because I think it's a particularly offensive and problematic one, although it's probably not unique. This kind of thing happens all the time, but it is something I just want to spend like 1 minute to highlight. So most of the listeners are probably familiar with this. If you don't know the name Olivier, you probably do know the facts of the case as you're reminded of them. This is the evangelical street preacher in Mississippi, and who would preach at this near this amphitheater in a public park and was kind of forced into one of these free speech zones, which that's the center of my problem, why I think it was worth highlighting. And basically, Joseph will get into the facts, but right, he went outside of that free speech zone because nobody's listening to you in that free speech zone. People are in the amphitheater, so he went to the amphitheater and suffered the consequences, and is now at the Supreme Court on a technical legal issue. But I mean, to me, this is just so uniquely offensive because the First Amendment speech clause is meant to protect the exercise of free speech in the public square. This is almost literally the public square, right? Like this is a public amphitheater in a park. And protections on speech are at their highest when they're on controversial matters of things like politics or religion, right? Like these are the most highly protected areas of speech that were the impetus for creating the Bill of Rights, to make sure that these things were protected so that people can go out and say unpopular things about politics, about religion, about culture, about policy, without fear that the government was going to suppress a viewpoint. So admittedly, these are viewpoint neutral laws, right? They're not saying like street preachers have to be in this free speech zone, but ACLU representatives or like left-wing politicians can be in the amphitheater. Like it is neutral, but restricting certain kinds of speech or most kinds of speech from the public square, to me, this is just like a textbook case of exactly what the First Amendment was enacted to prevent. So I think it's a really important underlying issue, and I hope that Olivier does manage to prevail. And when this goes back down, I would like to see either this case or another case, somebody challenge some of these free speech zone and in public place laws on their merits, that they're facially unconstitutional. And with that, I will turn it over to Joseph, and we'll get into what this argument is actually about.
Yeah, no, you're absolutely right. It is, I mean, an egregious concept that the very type of speech that the Constitution is designed to protect isn't really being protected very well here. And that's part of why this is such an important case. But before moving into the procedural history, I do want to note, like you said, this case is similar to First Choice in that there's going to be lots of headlines out there saying whether for or against Olivier about how the Supreme Court's going to decide if a Christian street preacher can preach wherever he wants. That's not actually what's going on. It's a little bit different. And I would say that it's more important. So if your eyes start to glaze over a little bit during the procedural questions, just hang on, stay tuned. It's going to be worth it in the end, I promise. So you already kind of mentioned the facts. Olivier was this evangelical street preacher, broke a city ordinance that said you have to be within a certain within a certain kind of zone to be able to do your certain type of speech. He was arrested, convicted, and given a sentence. So he was fined, and then also had a 1-year unsupervised probation with like a delayed sentence. And very important to note is in that initial criminal proceedings, he pled no contest. So he didn't plead guilty, but he said, like, I'm not going to challenge it, just whatever, I'll take it and move on. Now, a few months after he was convicted, but still within that year where he was on probation, Olivier filed a Section 1983 claim against the city and against the chief of police. He's basically trying to get an enjoinder, an injunction against them from enforcing the statute in the future against him, saying that it violated his First and 14th Amendment rights. Now, the district court that he began in dismissed his case, as did the Fifth Circuit that upheld his dismissal. And the court's reasoning in both of those dismissals relied largely on Heck v. Humphrey, which is this 1994 Supreme Court case. Now there, a man named Roy Heck was convicted for the voluntary manslaughter of his wife and was sentenced to 15 years in prison. He appealed his conviction, and while that appeal was pending, he filed a Section 1983 claim against the federal prosecutors, claiming that they destroyed evidence, kind of had these different illegal procedures during the initial investigation. And in his claim, he sought monetary damages against those prosecutors. He didn't seek an injunction against any sort of future enforcement of a law, or he didn't seek a commutation of a sentence or his own release or anything like that. He said, I want money from these people that did this to me. And the court ruled against Heck. They said, no, you can't get this monetary damage. And the key precedent that was set there was that, and this is coming directly from Heck, when a state prisoner seeks damages in a 1983 suit, the district court must consider whether a judgment in favor of the plaintiff would, and this is the really key language here, would necessarily imply the invalidity of his conviction or sentence. So basically, in other words, in English, it's saying that a formally convicted individual cannot claim damages in a 1983 lawsuit that would necessarily imply the invalidity of his conviction. And really the big goal in Heck, at least part of the big goal in Heck, was to keep habeas petitions distinct from Section 1983 petitions. Right? There are these two different methods of protecting your constitutional rights. Habeas exists for those that are detained. Section 1983 exists for constitutional violations. And a big goal was to keep these two things separate. They didn't want to let a habeas petition slip into Section 1983. So they said, if your 1983 petition would invalidate your prior conviction, or would necessarily imply the invalidation of your prior conviction, you can't bring it in federal court. That's pretty much what happened in the court's dismissal. They said Olivier can't bring his lawsuit because doing so would necessarily imply the invalidity of his prior sentence. Right? He's saying that if you find this city ordinance that you were convicted against unconstitutional, you cast doubt on your conviction under that statute in the past, even if it's just, hey, I want an injunction, I'm not seeking for damages. So there's kind of the background. What is Olivier actually asking for in this case? And here he wants an injunction that makes it impossible for the city ordinance to be applied to him in the future. But like I said before, the big problem is that the court dismissed his case because getting that injunction would imply that his prior conviction was invalid. So Olivier is arguing kind of a few different things here. The thing they open with is that, represented by First Liberty, his attorneys are saying that he's seeking purely prospective relief, only forward-looking. He's not asking the court to change anything about his prior sentence. He's not asking for monetary damages. He's just saying, in the future, I don't want this thing applied to me because it's a constitutional violation. There was some skepticism expressed in an oral argument saying, well, still, even if you say that this statute is unconstitutional, or this ordinance is unconstitutional, doesn't that say something about your conviction? And kind of the next step in this logic is when his attorneys start to rely on a case called Woolley, another Supreme Court case. This one predates Heck by a decent bit. It's from 1977. Now, in Woolley, the facts are kind of interesting. There's a New Hampshire law, at least at the time, that required the state's motto, which was live free or die, to be visible on all license plates. There's a family named the Mainers. They were Jehovah's Witnesses, so they had a religious objection against this motto being on their car. They covered it up and just kind of drove around with it, like tape over it or scratched out the letters. The dad was arrested 3 times in the span of 5 weeks and convicted for violating this law. So he filed a Section 1983 lawsuit. In those, he was convicted. He didn't contest his convictions. He just kind of took them. So he filed a Section 1983 lawsuit asking for future relief. I don't want this to be applied to me again in the future. He didn't look for any damages. And he actually won. The court stated, here the suit is in no way designed to annul the results of a state trial, since the relief sought is wholly prospective. So he won because he was looking for a prospective injunction and not seeking damages. And that's kind of what's happening in this case. It's pretty similar. The city is trying to discard Woolley, basically, because it's pre-Heck. They're saying we have this new precedent that actually applies more specifically to this case. And they're also trying to argue that Woolley is kind of a special case. I mean, the guy was arrested 3 times in 5 weeks. They're saying it was such kind of a strange fact pattern and such a substantial burden that it shouldn't really apply anymore. And a few of the justices did kind of lean into, well, where does Woolley play into this, and pushed against the city a little bit on just kind of putting it aside. So the court, if they rule against Olivier, would either have to ignore or really cabin Woolley. And not to speculate, but we know the Roberts Court is generally wary of overturning precedent. Of course, they have. You can think of Dobbs and everything like that, but broad swaths, they tend to not want to do that. So that's kind of the first crux of his argument. The second part, and which might be a little bit stronger, at least based on how oral arguments went, is that Olivier is saying that he never had the chance to request relief under habeas corpus because he was never actually detained. He was never incarcerated. Habeas is for people that have been detained. He's saying that since I was never actually detained, I never had the opportunity to vindicate my rights under habeas. Therefore, the only avenue I have left is Section 1983. And if you say I can't bring a 1983 claim, I have no option really to vindicate my rights in a federal court. Now, he could get his, based on the Heck precedent, if it does actually bar his claim, he could go and get his record cleaned. He could get the state conviction overturned. There are a lot of procedural bars there, and the likelihood of that is actually, I would think, rather low. And it would take probably 20 plus years. And the justices did seem a little bit sympathetic to this claim. They said, it seems like we're kind of stretching Heck here if we say you can never vindicate your federal courts because you got convicted of a statute and pled no contest. And Olivier's attorneys closed by saying his is the exact type of case that Section 1983 exists to enable. His prior conviction, they say, actually works to prove that he should win in this case. They're saying that because he was convicted in the past, that shows a credible threat that his constitutional rights will be violated in the future. And that's what Section 1983 exists to do. It says if the federal official violates your constitutional rights, you have a capacity to vindicate them in federal court. And very interestingly, in Heck, 4 justices signed on to a concurrence by Souter that basically said the same thing that Olivier's attorneys are arguing. In that concurrence, so they only had 4 justices, so they didn't get the majority, and it's not good law. But we have seen this logic in some circuit courts. But there they said if people who weren't imprisoned have to get their prior conviction invalidated before they can bring a 1983 claim, quote, the result would be to deny any federal forum for claiming a deprivation of federal rights to those who cannot first obtain a favorable state ruling. So kind of wrapping things up together, sorry if you guys are glazing over, this is where the kind of upshot comes in. In this case, the court will greatly impact whether or not an individual who's been convicted of a crime and who believes their constitutional rights have been violated via that sentence, if they can ask a federal court for a remedy. The city's brief is arguing that this isn't a religious liberty issue, it's a procedural issue. And on one face, I kind of agree, right? This isn't about the merits of Olivier's claim. It's about, can he bring this 1983 suit? And that's really important to understand for this case. It's not about if a state can restrict where a street preacher is allowed to do his thing. That plays into it, but that's not what this particular thing is about. And honestly, I think that fact makes this case way more important because that's going to impact way more people. If this was just a First Amendment issue, it would still impact a lot of people. But now this is just a constitutional issue more broadly. If Olivier loses completely, it could make it virtually impossible for somebody who's been convicted under a law that they feel is constitutional to protect their rights if they were never actually imprisoned. So, Frank, I'll catch my breath, hand it off to you to take us home.
Yeah, no, I think you did a really good job of summarizing this. I'll just point at a couple of observations I have about both the Heck and the Woolley precedents and where I think this should go. I'm not a Supreme Court whisperer. I have no interest in predicting how this is going to go, but just at first glance, I mean, the Heck case is, unfortunately, I think it's a pretty bad set of facts to be the precedent for a case like this of when you can invoke 1983 for something that you've already been convicted or pled to. Because like you read the facts, I won't go into them too much, but they're so wonky, right? This is just so different that like what Olivier did was, right, go preach, get convicted of like a minor violation for, speaking in the wrong place. The defendant in Heck, I mean, he was convicted of manslaughter of his wife, and he wasn't even looking to get out of jail, right? He wasn't saying like my constitutional rights were violated by my inability to kill my wife, right? Whereas that is basically what Olivier is saying. My constitutional rights were violated, not in the investigation, not in the way I was arrested, but in the nature of this speech zone itself. So in my mind, they're different just for that reason. And then of course you have the fact that Heck was about the proper habeas course of action, whereas Olivier was never in jail. So he could be kind of left without a remedy in a case like this. And just like we had said above, that the problem of the first choice case is that you could ultimately leave a large swath of people who have had their rights violated without 1983 relief, and that's a problem. The other thing I would say is that the Woolley case, this is so interesting, right? Because Heck did not overrule Woolley, right, explicitly. And that seems to be the kind of implicit alternative argument that the city makes here, right? Is that, well, Woolley was pre-Heck. It's like, okay, well, I think you could easily distinguish them, right? Heck was a problem because he had habeas relief. Woolley, not the same thing. Or shouldn't have been, because it was only looking at forward, potential new convictions or arrests going forward. So Woolley's, I think, distinct on its facts from Heck. I think it's pretty easy to distinguish. I also think it's pretty easy to say that Olivier's case looks more like Woolley's than like Heck's, right? And I think one of the interesting things, I think the second part of the city's argument against Woolley applying here fails, right? Because they say either one, it's pre-Heck, which I don't think is a good argument, although you never know. We have some quirky precedents, like religious liberty aficionados who listen to this will know how the Lemon case died, right? The 1971 Establishment Clause case that was kind of used less, and then in the Kennedy versus Bremerton case in 2022, the opinions, well, of course, we've long abandoned the Lemon test, and we're like, wait, when? Right? So sometimes it seems that things are not explicitly overruled, but still become like slowly non-precedential in some mysterious process. So it's not impossible that the court could find that Woolley is no longer controlling law, but I think it's unlikely. And if you do grant that Woolley is still good law, I think the city's other argument is curious because they say, well, this is a special case. Like I'm going off your notes, Joseph. Woolley was a special case that dealt with the daily life of the Maynards with clear threat of massively interfering with his life. I think that's true in Olivier as well. I mean, he's a street preacher. What he does and he goes and preaches the gospel. And if in his city he's not allowed to preach in the place where he's able to get his message across, I think that's a special case that deals with the daily life of Olivier with a clear threat of massively interfering with his life. I think it's an interesting analogy if you play that out. So yeah, bottom line is I think it's a really interesting argument. I have no prediction about how the court's going to go with whether it will distinguish Heck, although I think it should, whether it will actually weigh Woolley as precedential, which I think it should. But yeah, the long and short of it is exactly what you said, Joseph. Olivier never really had the chance to request relief via habeas because he was never incarcerated. So what else does he do to vindicate constitutional violations if he can't use 1983 because he pled previously and is looking to remedy that going forward? And the one thing I'll end with here is just a practical note that, in a case like, if you're talking about being convicted of a major crime, right, by the time you plead guilty to something like voluntary manslaughter, like what Heck did, right, like you've thought about this, you've considered what your rights are, and you probably have lawyers telling you the consequences of a potential guilty plea or conviction, and you're going to weigh that heavily and consider your options, including 1983 actions, other constitutional claims, before you plead guilty to something that carries heavy jail time. But Olivier was never in jail. This is an infraction, basically, right? So my concern here is that if you say, well, once you've pled on these types of issues, you don't have 1983 recourse. That's a huge problem because, I mean, think of like a traffic violation is not a great example, but something like that, like people plead to them out of convenience all the time, right? Like you don't have the chance to like heavily weigh the effects. It's just like, okay, he got cited for preaching in a non-speech zone. You just plead, pay the fine or whatever, and move on. It's not something you're going to weigh very heavily before considering, your constitutional rights, your right to file a 1983 action. So I do worry that if Olivier does not prevail here, that this is a huge problem because I think there are theoretically a lot of cases where people can be convicted or choose to plead guilty to very minor infractions that do in fact involve free speech or free exercise of religion violations. And if they plead out of convenience and then realize they have no 1983 recourse, I think that's going to be a big problem in a lot of cases.
Yeah, and kind of adding to the personal capability to bring this sort of loss, to bring a 1983 claim. I'm not totally certain if it was like a hypothetical or if it was actually happening, but the justices talked about, well, what if there was like one of Olivier's friends who also filed a 1983 claim who hadn't been convicted under the city ordinance? Would he be barred from filing the claim, even though he's done the exact same thing? And most of the people said no, actually, his case would proceed. And again, I'm not sure if it actually is proceeding or if that was a pure hypothetical, but the concept that he loses his rights entirely to file a 1983 claim because he pled no contest, it just is a little bit of a strange gap in the law. It would be a strange gap in the law.
Yeah, I agree. All right. Well, we dove deep into the weeds here, but if nothing else, hopefully we have given you listeners a good kind of overview of what actually happened in First Choice and in Olivier at the Supreme Court last week and what's actually being argued in the Supreme Court, because guarantee you, if not now after oral argument, that when these cases have decisions come down at the end of the term in 2026, there will be all kinds of reporting, and some of it will almost definitely not be focused on the actual technical legal issue in play. So hopefully we've cleared those up for you. And with that, we thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you'll like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening. And if you want to support the work that we're doing, you can do so at napalegalinstitute.org. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.